Right now, tens of thousands of green card applicants across the United States are waiting. Some have been waiting for years, and in 2026, a specific pattern is emerging, one that is quietly causing applications to stall, get flagged, or in some cases get denied, not because of fraud, not because of criminal history, but because of a procedural mistake that most applicants don't even know they're making. And if you are currently in the green card process, whether you filed an I-485, you're waiting on an I-130, or you're stuck in employment-based retrogression, the next 12 minutes may be the most important 12 minutes you spend on your case this year. Stay with me. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't do rumors, I don't do panic, I do policy, backed by official sources, regulatory language, and real procedural analysis that helps you make better decisions about your immigration future. Before we go further, I want to be clear about something important. I am not your attorney, and this content is for educational and informational purposes only. Immigration law is highly fact-specific, and your individual circumstances matter enormously. Always consult with a licensed immigration attorney about your specific case. What I can do is give you the information framework. What your attorney does is apply it to your life. Now, let's get into it. To understand what's happening right now, you need to understand the environment green card applicants are operating in as of 2026. Processing times at USCIS have shifted significantly. The agency has been navigating a combination of staffing realignments, policy directive updates from DHS, and the downstream effects of backlogs that built up over the past several years. This is not speculation. USCIS publishes processing time data directly on their website, and those numbers tell a very clear story. Delays are real, they are category-specific, and they are not distributed evenly across applicants. Here is where the mistake begins. Most applicants, and I mean the overwhelming majority, treat the green card process as a waiting game. They file their petition, they receive their receipt notice, and then they wait, passively. They check the USCIS website occasionally. Maybe they call the 1-800 number once in a while, and they assume that as long as they haven't received a denial, everything is moving forward correctly. That assumption is costing people their cases. Here is what's actually happening in 2026. USCIS has increased the rate at which it issues requests for evidence, what immigration practitioners call RFEs, as well as notices of intent to deny, sometimes called NOIDs. These are formal agency requests that require a response within a specific time frame. And the critical issue is this. In a significant number of cases, applicants are either missing these notices, responding to them inadequately, or, and this is the one that affects people most, failing to update their address with USCIS, which means the notice goes to an old address and they never receive it at all. Under the Immigration and Nationality Act, USCIS has the authority to deny an application for failure to respond to an RFE within the designated time frame. That authority is grounded in 8 CFR 103.2b13, which gives the agency the right to treat a non-response as an abandonment of the application. In plain language, if USCIS sends you a request and you don't respond in time, they can and do close your case. And in 2026, they are exercising that authority more consistently than they have in recent years. But here's where this becomes critical. The address issue is not the only problem. Even applicants who are receiving their mail correctly are making a second mistake that is just as damaging, and it has to do with the Visa Bulletin. Let me explain this carefully, because the Visa Bulletin is one of the most misunderstood documents in the entire immigration system. Every month, the U.S. Department of State publishes the Visa Bulletin. This document controls whether an employment-based or family-based green card applicant is eligible to move forward with their case. It does this through what's called a priority date system. Your priority date is generally the date your petition was filed. The Visa Bulletin publishes cutoff dates for each visa category and country of birth. If your priority date is earlier than the cutoff date listed in the bulletin, your date is considered current, meaning you may be eligible to proceed. If your priority date is later than the cutoff, you wait. Now here is the mistake most people are making in 2026 specifically. The Visa Bulletin has two charts. Chart A, called Dates for Filing, and Chart B, called Final Action Dates. These are not the same thing. They serve different purposes. Chart A tells you when you may be able to file certain forms, even if your visa number isn't technically available yet. Chart B tells you when a visa number is actually available for final adjudication. USCIS periodically announces through a separate policy update on their website, which chart applicants should use in a given month. And this is where the confusion creates real damage. Applicants who rely on Chart A dates when USCIS has designated Chart B as the operative chart for that month may believe they are eligible to file when they are not. Conversely, applicants who wait for Chart B dates when USCIS has authorized Chart A filings may be missing valuable windows to submit forms, lock in priority dates, and trigger employment authorization eligibility. This is what many green card applicants are misunderstanding, and the failure to track this monthly, not annually, not quarterly, is causing people to either file too early, file with the wrong chart, or miss filing windows that may not reopen for years. Let me show you what this looks like in real life. Consider a hypothetical situation, one that is representative of cases immigration practitioners across the country are navigating right now. A software engineer from India. We'll call him Arjun. He's been in the United States on an H-1B visa for 9 years. His employer sponsored him for an employment-based green card, specifically an EB2 category, back in 2019. His priority date was established. He filed his I-140, his immigrant petition, and it was approved. He's been waiting ever since for his priority date to become current under the EB2 India category, which, as most of you know, has one of the longest backlogs in the entire system. In early 2026, Arjun checks the visa bulletin and sees that the Chart A date for EB2 India has moved forward enough that his priority date appears to be in range. His company changed addresses, and his own personal address had changed as well when he moved apartments last year. He updated his employer's records. He did not update his address with USCIS. USCIS, meanwhile, had sent him a request for updated biometrics, a standard step in many employment-based cases, to his old address. He never received it. The deadline passed. His case was administratively closed. Arjun's situation is not unique. It is not a failure of the immigration system in the dramatic sense. It is a procedural gap, a gap between what an applicant assumes is happening and what is actually required of them, and it is entirely preventable. That is why I'm telling you this today. Now, there's one detail most people are missing when it comes to protecting their case in this environment, and it involves something called the Alien Registration Number, or A number, and how it connects to your USCIS online account. USCIS has been expanding its online case management system, and in 2026, the agency has increasingly shifted toward electronic notice delivery for applicants who have active USCIS online accounts. This is significant for 2 reasons. First, if you have a USCIS online account linked to your case, electronic notices may be considered legally delivered even if you don't open them. Second, many applicants created online accounts, linked their cases, and then stopped checking those accounts regularly, sometimes for months. Under current USCIS policy, when an applicant has opted into electronic communication through an online account, the agency's delivery obligation may be satisfied at the moment the notice is posted to the account, not when you read it. That means the response clock is already running even if you haven't logged in. This is grounded in USCIS's own policy guidance on electronic notice delivery, which the agency updated in alignment with broader DHS administrative modernization efforts. This could affect you even if you're not in an employment-based visa category. Family-based applicants, asylum adjustees, and diversity visa selectees who have USCIS online accounts tied to their pending I-485 cases need to understand that their responsibility to monitor that account is no longer optional. It is a legal procedural obligation that carries real consequences. So what do? Here is a clear, structured action plan for anyone currently in the green card process. Step 1. Update your address with USCIS immediately. Do not assume that because your employer has your new address or because you updated your driver's license that USCIS has been notified. You must file Form AR11, the Alien's Change of Address Card, directly with USCIS. This can be done online at uscis.gov. This step is not optional. Under federal law, non-citizens with pending immigration matters are required to notify USCIS of address changes within 10 days of moving. Step 2. Log into your USCIS online account and check your case status and any pending notices at least once every 2 weeks. If you don't have an account and you have a pending case, create one. Understand what your account shows, specifically whether any RFEs, biometric appointment notices, or interview notices have been issued. If you see something you don't understand, contact your attorney immediately. Step 3. Access the visa bulletin every month, the first week of the month when it's typically released, and cross-reference it with the USCIS website to confirm which chart the agency has designated as operative for that month. Write your priority date down. Know it. Understand how close or far your date is from the current cutoff. Step 4. Document everything. Keep copies of every form you filed, every receipt notice, every RFE, and every response. Keep a chronological log of every USCIS interaction. If you ever need to file a mandamus lawsuit, a legal action to compel USCIS to act on an unreasonably delayed case, that documentation record will be essential for your attorney. Step 5. If you have received an RFE or a NOID and have not yet responded, stop everything and contact a licensed immigration attorney today. Do not attempt to respond to a request for evidence or a notice of intent to deny without qualified legal guidance. The stakes are too high, and the legal standard for an adequate RFE response is specific and demanding. Now, I want to spend a moment on the broader policy environment, because the context matters. The delays and procedural complications applicants are experiencing in 2026 are not happening in isolation. USCIS is operating within a broader DHS framework that has seen significant policy activity in recent months. There have been regulatory adjustments affecting how certain employment-based adjustment cases are processed, ongoing congressional discussions about comprehensive immigration reform that have not yet produced legislation with the force of law, and a federal court landscape that continues to produce rulings with direct implications for adjustment of status applicants, particularly in areas involving work authorization, travel, and protected status during pending applications. I want to be precise here. When people tell you that Congress is working on immigration reform or that a bill has passed one chamber, that does not change your current legal obligations or protections. Legislation that has not been signed into law by the President is not law. Proposed regulations that have not been finalized through the Administrative Procedure Act's notice and comment process are not yet binding, and court rulings, depending on their jurisdiction and whether they are being appealed, may or may not apply directly to your case. However, and this is the important nuance, these developments do affect the operational context in which USCIS is working. Agency priorities shift, processing timelines adjust, enforcement postures evolve, and applicants who are monitoring these developments in real time are in a fundamentally better position than those who are not. That said, however, this protection may not be permanent. Favorable court rulings can be reversed on appeal. Policy guidance can be rescinded. Visa bulletin movements can and do retrogress, meaning dates that move forward can move backward in subsequent months if demand in a particular category outpaces the available visa numbers. Assume nothing is permanent. Stay informed. Stay current. Before I give you the outro, I want to take 60 seconds to say something that doesn't get said enough in immigration content. The stakes in this process are not abstract. When your green card case stalls, it's not a paperwork inconvenience. It affects whether you can travel to see a dying parent without risking your ability to return. It affects whether you can take a promotion at a different employer without jeopardizing your priority date. It affects whether your child, who may have been a derivative beneficiary on your petition, ages out of eligibility before the case is resolved, a tragedy governed by the Child Status Protection Act that too many families discover only when it's too late. It affects whether your spouse can work. It affects your financial planning, your housing decisions, your children's educational stability. Immigration status is not a legal technicality sitting in a file at a government agency. It is the structural foundation of your life in this country, and treating it as a passive process, as something that will just work itself out, is the most expensive mistake you can make. You deserve accurate information. You deserve to understand this system, and you deserve to be the most informed person in the room when you sit down with your attorney. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If today's video gave you clarity or helped you understand something about your case that you didn't before, please like this video. It tells the algorithm that factual immigration content deserves to reach more people, and it does. Drop a comment below and tell me your visa category and where you are in the process. Whether you're waiting on an I-130, stuck in EB-2 retrogression, navigating an RFE, or just starting the adjustment process, let me know, because your questions shape the content I make next. And if you know someone who is in the green card process right now, a coworker, a family member, a friend, share this video with them. One piece of accurate information at the right moment can change the trajectory of a case. Don't let the people you care about navigate this alone. I'll see you in the next one.